bow your head. Our Heavenly Father, thank you again for this day, and thank you for the love that you send to us each and every day. Father, we just pray that we put you first in what we do each and every day. Father, as we do the county business, may we do it in a Christ-like manner and that's most pleasing to you as well. Father, I just ask you to be with our Commonwealth of Kentucky and all the first responders, that you watch over them and take care of them as well. Father, I just pray that you take care of each one of the county officials, that Father, that they put you first in what they do each and every day. Father, again, I just ask you to be with our nation and watch over our nation and keep our military and missionaries around the world out of harm's way as well. Father, as we turn to you for leadership and guidance, we just thank you and love you for what you do for us each and every day. Father, again, out of your mercy and your grace, please forgive us where we've failed in so many ways. It's in Jesus' name I pray. Amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
So the first thing that we have is the scheduling of our June, August, and I think there may have been an issue with October, fiscal court meetings, if y'all will look at the calendar. So, for the month, I do have one, I know it says June and August, I think one of these is supposed to be May. I will not be here next week for the May regular, I know there's several things on there, second reading of the budget, the library's presented the budget. It's totally up to you if you all wanna have the meeting, but I will not be here next Thursday.
Because they've made it out,
Mhm.
so we're gonna move that over.
That's totally up to you all, what we can do with that. You thinking we get the 20th? Is that right?
The 21st, the 20th, the 23rd. Pretty much any day other than the 22nd and the 24th.
I can do the 21st, I can do the 23rd.
I actually can do the 21st or 22nd, closing days of school.
Okay, so it's the 23rd?
May, you said May?
I'm good.
May 21st is election?
May 23rd.
Okay.
Yeah.
I'm good. May 23rd, at 1 o'clock.
1 p.m.
So you're gonna move the regular one, Jamie, from the
Yes.
9th to the 23rd?
Yes.
Okay.
All right, and then in June, 1 o'clock. June 13th is the joint magistrate and judge executive conference. I know 3 of the 4 of us will be going to that, so we need to look at June's as well.
I think we looked at 20th as a possibility.
Possibility,
I'm good on June 20th.
okay?
I'm good.
1 o'clock.
1 p.m.
June 20th.
I'm not sure, August, did somebody have an issue in August?
I won't be, Jeff's not here, if it's a local issue, they just look it up, it's, you guys going to the local governor's
It's the
office.
8th.
It's the 8th.
That's the governor's, yeah, after budget year, I'll probably get that one as
And
well.
I looked it up, and that's what it said, I just,
Okay.
well, you know.
So August is supposed to be the 8th?
Yeah, it's supposed to be the 8th is the regular, but if it's the governor's local
I'll show
issues,
you what
then
it says here.
I would say,
We don't want some of this, I think it's just now, save the day.
oh, yeah, mm-hmm. Okay. It's the 15th, little like for you in August.
I can do that.
You ready to go on the 15th?
15th, come on.
I won't be here.
I won't be here.
Okay, then 2 won't be here.
I won't be back until the 28th,
Oh, when do you leave?
the 8th.
What about Tuesday the 6th?
Yeah.
Yeah.
The 6th won't work. There's no way I get my church to the 13th.
When's he leaving?
I'm leaving
He's
the 8th and I'll be
leaving the
back
8th.
the 28th.
You good to go 6 or 7?
Yeah,
just on me on the 15th, I can get Christie to come in and take minutes. I've got a parks meeting that day.
Yeah, but he won't be here anyways. I'd rather have him or when we go set a tax rate.
So what
But I
about?
mean,
I was
we
still
gotta
do
pay
the
the
seventh.
bills.
What about the seventh?
He's got 4 things in court. Wednesday's court.
Local issue starts.
What
on-
time?
And local issue starts on the 7th. I mean, we could do Monday or Tuesday, well, no, because he's on days, but even if we moved it to later in the evening, I mean, if we did like 5 o'clock.
I can't on the sixth, but I could on the fifth.
We're talking about August.
How would we?
Yeah.
I'm good August the fifth.
To at least pay bills, and then have a special call, another special call, and then one.
I can be here full time.
But you have it at 5 o'clock.
Is that an issue for you?
5 o'clock on the 5th.
Yeah.
Say what day?
Monday the 5th at 5.
And then you said you may have a special call at the end of the month.
At the end of the month, when he gets back, yeah, we'll have to.
Okay.
You get back on the 20, when is your schedule on the 29th?
Working nights.
So we could potentially do it the morning of the 29th, or no?
You wanna do it in the morning, right after you get back?
The 29th.
You're getting back the 28th. Okay.
Or if we gotta have it set for September 1st,
Like 11 o'clock.
Also, at the 30th.
okay?
I mean, I can do either one, I just, if you get hung up or something, I wanna.
Here's the thing, if you set rates and you take the compensating rate, but if you're gonna have hearings, that's gonna push things back. So we need to be sure that we, because I have to have tax bills to the sheriff by the 15th of September. So I've got, the latest that I would be able to get the county's rates would be that last week of August.
That includes the hearings.
I mean, they have to be
Hearings.
set, I have to send them to the vendor,
So you have to have all the hearings done before the 29th, is what you're saying.
yes.
How about 27th?
Well,
I'll be back the 27th. Be back on, I'm sorry, I'm looking at the wrong one.
but we'll have to set the rates
We'll have to
before then.
set before then.
If you're gonna do,
If you do more than the compensation.
If you do, yeah, if you do any,
well,
well,
you have to have a hearing and all that stuff.
yeah, even if you take 4%, you still gotta have it here.
And there is a possibility about the 5th, we could do it, depending on the state.
Depends on when we
gets
get certification.
Yeah,
Yeah.
so I don't know if we can set another date yet, so we know,
When we get them.
hopefully we'll have it before then, and we can do it on the
Yeah.
5th. Pray,
At least get it started.
yeah. I bet you we don't have it early,
Depends on how quick they get it to us in July.
but I've seen that early before. I've seen them in July before.
Yeah. Okay. All right, so we'll hold off on the second one, and
So
then
right now, we're on the
August the 5th
at
at 5, and then October.
So, we could, we'll meet there. I can meet.
What's the week of the 14th?
I am fishing. And I'm definitely going.
What about the 3rd?
How about the 4th?
The
What
4th,
month are we looking at?
October. Does anybody have any issues with October 4th?
What time? 1?
Or,
I could do it on the 3rd, or I could do any time before 1 on the 4th.
Yeah, like 11.
That's still gonna push back. You'll have to contingent that my reports will be.
Okay.
what about the week 21st, 25th?
I just worry about the bills that we have, like, some of them, you know, we always pay around that time, I'm just curious if that's gonna put some of them over the 30 days. Cause I think the one in May, we're probably not gonna tell a couple that was not told. do 21st, that's the naval trip.
I don't think either one of us agree.
The 3rd or the 4th.
I'm good with it.
11 a.m. on 4th, did you say 11 a.m. on the 4th?
That'd be good with me.
Anytime that one's good for
Third,
me.
fourth.
The 4th at 11 a.m. on Friday.
I'm good with that. October the fourth,
Jamie, we have a comp plan meeting that day,
A what?
a comprehensive plan.
Yeah, I'll just have to move it up.
Okay.
Yeah. Yep.
So 11 o'clock on the 4th.
And that's spring break for some and other counties,
Oh, okay.
so, yeah. Lyon County spring break's the next week, but some of the, like Angela and, so, I just made that move it.
I'm gonna put it out that week of June or October 7th, is getting married.
October.
November the 7th.
Oh, yes, okay. Any other issues that we know of for the remainder of the year?
It's almost every month.
Got those.
You said something.
Only one we didn't touch.
Yes, sir, I will.
Do we want a motion for that, or y'all just move them?
She'll just call me.
Okay. Gotcha.
Alright. So for the record, the fiscal court meetings for the month of May, June, August, and October have been set as May 23rd at 1 p.m., June 20th at 1 p.m., August the 5th at 5 p.m., and October the 4th at 11 a.m. Alright. You all should have an updated copy of ordinance number 04-2024. This is the solar energy system installation requirements. I will entertain a motion to accept the ordinance as printed with the following option on page 6 for the 16 cents per square foot of any applicable SES not to exceed a total fee of $500,000. Motion by Bobby,
Second.
second by Jeff.
This will be the second final reading of Lyon County, Kentucky ordinance number 04-2024, a solar energy systems installation requirements ordinance. A complete copy of this ordinance is available in the office of the Lyon County Judge Executive during normal business hours. Lyon County, Kentucky ordinance number 04-2024 is an ordinance relating to repealing Lyon County Fiscal Court Ordinance 01-2024 and replacing it as set forth herein, establishing licensure requirements for solar energy systems in Lyon County, Kentucky. Whereas the Lyon County Fiscal Court, pursuant to the powers and duties vested in it by the Commonwealth of Kentucky, has previously adopted Lyon County Ordinance 01-2024, addressing and establishing minimum setbacks, screening and decommissioning requirements for solar energy system installations. And whereas Lyon County Fiscal Court wishes to repeal Ordinance 01-2024 and replace it with a new ordinance as set forth herein. And whereas pursuant to KRS 67.083, the Lyon County Fiscal Court has granted the authority to undertake all necessary governmental actions for the welfare of the community, and specifically is empowered pursuant to KRS 67.083 sub H and 67.083 sub N for the regulation of commerce, for the protection and convenience of the public, and with the power to protect and conserve the county's natural resources, including but not limited to soil and wildlife, to safeguard the livelihoods and well-being of its residents, and whereas KRS 278-718 became effective June 29, 2023, and further provides that an ordinance permit or license issued by a local government enacted under the provisions of Home Rule under KRS Chapter 67080, 67083, 67850, 67922, 67860, 67C101, and 82.082 shall have primacy over the provisions, including setback requirements, set forth in KRS 278-700, 278-704, 278-706, 278-708, and any conflict between an order of the board and a local ordinance, permit, or license shall be resolved in favor of the local government's ordinance, permit, or license. And whereas the Lyon County Fiscal Court finds it necessary and appropriate to provide reasonable safeguards which mitigate potential nuisances such as soil erosion, water runoff and erosion, large-scale loss of agricultural land, and impacts to local flora and fauna, among others, created by large-scale ground-mounted solar energy systems that defined herein in order to protect adjoining properties and public rights-of-ways. And whereas the Lyon County Fiscal Court desires to exercise its authority pursuant to this subsection, and now therefore be it ordained by the Fiscal Court, County of Lyon, Commonwealth of Kentucky, as follows. A, A, definitions, building, any structure having a roof supported by columns or walls and intended for the shelter, housing, or enclosure of any individual, animal, process, equipment, goods, or materials of any kind or nature. 2, merchant electrical generating facility, means, except for a qualifying facility as defined in KRS 278-700 sub 7, an electricity generating facility or facilities that together with all associated structures and facilities, sub A, are capable of operating at an aggregate capacity of 10 megawatts or more. B, sell the electricity they produce in wholesale markets at rates and charges not regulated by the Public Service Commission. 3, solar energy system, a device, including its components and subsystems that collect solar energy for electricity, 4, electricity generation, consumption, or transmission, or for the thermal applications. SESs are in turn divided into 3 types depending on how the system is incorporated into existing land use. A, integrated solar energy systems, integrated SES. An SES where the solar materials are incorporated into the building materials such that the building and solar systems are reasonably indistinguishable, or where solar materials are used in place of traditional building components such that an SES is structurally an integral part of the house, building, or other structure. An integrated SES may be incorporated into, among other things, building facades, skylight shingles, canopy light, or parking meter. B, rooftop solar energy systems. An SES is structurally mounted to the roof of a house, building, or other structure and does not qualify as an integrated SES. C, ground-mounted solar energy systems. An SES that is structurally mounted to the ground and does not qualify as an integrated SES. Ground-mounted SESs are subcategorized as follows. Sub A, small-scale ground-mounted energy systems. Small-scale SES, which is a ground-mounted SES with a footprint of less than 2,500 square feet. 2, intermediate-scale ground-mounted energy systems, intermediate-scale SES, which is a ground-mounted SES with a footprint between 2,500 and 1 square feet and 40 acres, which does not constitute a merchant electric generating facility as provided in KRS 278-700 sub 2. 3, large-scale ground-mounted solar energy system. A large-scale SES means a ground-mounted SES with a footprint of more than 40 acres. This term also includes any non-exempt SES that, irrespective of footprint, size, or configuration, constitutes a merchant electric generating facility as defined by the terms of KRS 278-700 sub 2 and is otherwise subject to review and approval by the Kentucky State Board on Electric Generation and Transmission Siting. 4, decommissioning plan for ground-mounted SES, a plan prepared by a licensed engineer that establishes the party responsible for the decommissioning, the anticipated life of the project, the estimated cost for removal of the SES facility, the cost for restoring the land to its original condition, and all other plan information required by this ordinance. 5, enlargement. To increase the size of an SES footprint or relocate an SES footprint to an area of land not included as part of an original license's application or any change which would exceed the scope, its height or decrease setback or buffer of the original license's approval. SES enlargement does not include the repair, modification, retrofitting, or enhancement of a licensed facility, provided such repair, modification, retrofitting, or enhancement does not violate the terms of this ordinance or condition of the license's approval. 6, exempt solar energy systems, exempt SES. An SES that is a SES that is a facility of a municipally owned electric system or public utility regulated by the Kentucky Public Service Commission or the Federal Energy Regulatory Commission, which is exempt from planning and zoning requirements under KRS 100-324. 7, non-participating property. Any property that is not participating property. 8, participating property. The property on which a solar energy system is regulated by the terms of this ordinance is to be constructed in whole or part. This includes any property of which the owner has provided their signatures on a written or recorded agreement explicitly consenting to be a party to the licensure application for the construction of an SES. Such signatures shall constitute prima facie evidence of the owner's consent and or agreement to any of the terms set forth in the licensure application, including the waiver of any setback requirement for non-participating properties subsequently defined herein. 9, physical construction SES facility. The excavation or movement of earth, erection of forms or structures, or similar activities undertaken in the construction of an SES facility. This term does not include any activity or construction undertaken prior to the issuance of all required certificates, approvals, and permits, if any, as required under KRS 278 and other applicable state statutes. 10, responsible entity. The owner of the solar energy system and related improvements irrespective of land ownership by fee, simple, title, lease agreement, or other instrument, the responsible entity is the applicant under the terms of this ordinance. 11, SES footprint. Area calculated by drawing a perimeter around the outermost SES panels and any equipment necessary for the equipment to function, such as transformers and inverters. The footprint does not include perimeter fencing or visual buffers nor transmission lines or portions thereof that are required to connect to an SES to a utility or customer outside the SES perimeter. 12, setback. The minimum distance established by this ordinance measured from the property line of a non-participating property or boundary of a public roadway or rail line to the nearest portion of an SES footprint or other regulated SES feature. The setback distance required by this ordinance is to be contained within the boundary of a participating property and is the minimum distance from a non-participating property or public roadway or rail line boundary that an SES footprint or other regulated SES feature is allowed to be constructed. 13, siding board regulated SES. An SES that constitutes a merchant electric generating facility under KRS 278-700 Sub 2. The construction and siding of which is subject to review and approval of the Kentucky State Board on Electric Generation and Transmission Siding. A merchant electric siding facility is an electricity generating facility or facilities that together with all associated structures and facilities are capable of operating at an aggregate capacity of 10 megawatts or more and sell the electricity produced in the wholesale market at rates and charges not regulated by the Kentucky Public Service Commission. B, applicability. This ordinance and its requirements for licensure shall apply to the siding, construction, installation, enlargement, operation, maintenance, and decommissioning of large-scale SES facilities in all unincorporated areas of Lyon County, Kentucky. The requirements of this ordinance shall not apply to the following. So A, integrated SES. B, rooftop SES. C, small-scale SES. D, intermediate-scale SES. And E, large-scale SES for physical construction began prior to the effective date of this ordinance, provided 1. Physical construction is completed within 2 years of the effective date of this ordinance. 2. The SES footprint is not thereafter cumulatively enlarged by more than 5%. C. Licensure required and renewal license. Prior to the commencement of physical construction or enlargement of a large-scale solar energy system SES, the responsible entity, applicant, must obtain a Lyon County Solar Energy Systems license. Additionally, a renewal license shall be required, concomitant with the updating of the decommissioning plan stipulated in section 4D hereafter. All applications and supporting documentation for licensure shall be submitted by the applicant to the Lyon County Planning Commission for determination of conformance with the requirements of this ordinance. A request for licensure shall contain the following. A, an application for licensure that includes 1. The name of the applicant and the owners of the participating party. 2. The street address and tax map parcel number of the property for which a license is sought to include all participating property. 3. The current mailing address and phone number of the applicant and the owners of the participating party. 4. A copy of the deeds and lease agreements for participating property. 5. A listing of the names, mailing addresses, and property addresses, including tax map parcel number of all adjoining non-participating property owners, to include all owners within 2,500 feet of the proposed SES footprint. 6. A written description of the proposed facility that includes a statement of conformance with the requirements of this ordinance. And 7. A signed statement of the applicant and all participating property owners attesting to the truthfulness and exactness of information supplied in this application. B. Supplemental documents and exhibits that include 1. 24 copies of the site plan drawn to a scale of no greater than 1/100, which illustrates A. vicinity map denoting the location of the proposed facility, B. property lines of participating properties and adjacent non-participating properties, public right-of-way and rail lines, within 2,500 feet of the SES footprint. To scale, this information may be provided on a separate sheet at a scale of no greater than 1:300. C. Required setbacks with plan notes detailing the minimum distance to be provided from an SES footprint to the boundary of non-participating properties and public streets and rail lines. D. Adjoining roads and points of proposed access to the facility. E. The proposed location of all buildings, panels, inverters, transformers, and other on-site supporting facilities with plan notes detailing the height of such features. F. The proposed location of perimeter fencing with plan notes detailing type, height, and setback. G. The proposed location of vegetative buffer with plan notes detailing plant type, height, and anticipated mature height and opacity. And H. Any additional site plans, depictions, or accompanying descriptions which may be required to determine compliance with this ordinance. C. A decommissioning plan and surety instrument. D. A statement of the proposed large-scale SES's conformance or pending conformance with the requirements of KRS 278-700 with the State Board of Electric Generation and Siding and Transmission Sidings approval is required. 2. Fee entitlement for review and application. The The fee for the review and processing of licensure applications shall be 16 cents per square foot of any applicable SES. New language, comma, not to exceed a total fee of $500,000, period, and in new language. This fee should be payable upon the submission of the licensure application and is non-refundable. The fee should be paid to the Lyon County Planning Commission and thereafter equally divided between the Lyon County Planning Commission and the Lyon County Fiscal Court General Fund. 3, within 60 days of receipt of a completed licensure application, supplemental documents and exhibits and fee, the Planning Commission shall review and recommend that the application for licensure be 1, approved, 2, approved with conditions or required modifications, or 3, denied with cause stated. Such recommendation shall be reported in the minutes of the Planning Commission. Notification of the Planning Commission's recommendation shall be provided to the applicant and the Lyon County Judge Executive. 4, within 30 days of receiving a recommendation from the Lyon County Planning Commission regarding the licensure application, the Lyon County Judge Executive Office shall A, issue the requested license with or without conditions and modifications as deemed appropriate. B, deny the licensure request, providing cause for denial of writing. Or C, remand the matter back to the Planning Commission for additional review and findings. In such cases, the Lyon County Judge Executive shall specify the reasons necessitating further review with particularity. 5, should the matter be remanded, the Planning Commission is required to re-examine the application and support a report to the Lyon County Judge Executive within 45 days of the remand receipt. This report should address the specific reasons for remand and provide additional findings as requested. 7, when a license is issued, it should remain effective and unchanged, provided that the applicant maintains compliance with the terms of this ordinance and the conditions of the original approval. 7, upon the issuance of a solar energy systems license by the Lyon County Judge Executive Office, it should be recorded with the Lyon County Clerk's Office. To place notice upon all bona fide purchasers for value of the existence of said license. 8, in the event of denial, the Lyon County Judge Executive will provide the decision in writing, and it shall be sent via certified mail with return receipt requested to the applicant on participating properties and any non-participating properties, including the application. Furthermore, the denial will be published in accordance with the provisions of KRS 454, the Kentucky Revised Statutes. 9, any aggrieved party by either the issuance or denial of the license shall have a period of 30 days from the date of the recording of the license or publication of the denial of said license to file an action with the Lyon Circuit Court seeking judicial review. D, specific requirements. The following standards shall apply to the siting, construction, installation, enlargement, operation, maintenance, and decommissioning of large-scale SES. A, setbacks. The SES footprint should be set back no less than 2,000 feet from any non-participating property line and any right-of-way for publicly maintained roadway or rail line. B, perimeter access and screening. Access to the site must be controlled by a fence at least 8 feet in height with a vegetative landscape buffer provided between the fencing and the property line. The fence should be equipped with screening to help shield the facilities and equipment from view. Screening shall consist of 1, an 8-foot tall fence and a double row of staggered evergreen trees, minimum 5 feet in height at planting and maturing to a minimum 15 feet in height. 2, evergreen trees should be planted exterior to the fence and shall be set back no less than 15 feet from the property line. 3, screening shall achieve an opacity of 90% to a height of no less than 8 feet within 3 years of planting. 4, screening should be installed within 180 days of the start of physical construction and shall be maintained until the decommissioning of the SES is completed. And 5, all unhealthy, dead, or non-compliant planting shall be repaired or replaced within 90 days of such occurrence. C, lighting. Lighting on ground-mounted SES shall be limited to the minimum necessary for safe operation and shall be directed downward, incorporating full cutoff features and incorporate motion sensors where feasible. Lighting should be designed to avoid light trespass. Nothing in this section is intended to preclude installation of lighting required by the Federal Aviation Administration. D, decommissioning plan required. The applicant shall be responsible for the decommissioning plan provided by a registered professional engineer at the expense of the applicant and updated not less than once every 5 years, containing the following. 1, the anticipated life of the project and defined conditions upon which decommissioning will be initiated. 2, the estimated decommissioning cost, including removal of the solar energy system and related foundations, pads, underground connector lines and roads, transmission lines, and the revegetation and restoration of the property, including soils, to its original condition. And all calculations supporting the decommissioning estimate. 3, the manner in which the project will be decommissioned, including Provision and a timetable, such timetable not to exceed 5 years, for the removal of all structures and foundations, and for the revegetation and restoration of the property to its original condition. 4, the manner of SES component disposal, including the estimated recycled value of the components. And 5, a copy of any contracts containing specific agreements regarding decommissioning. E, surety instrument requirement. The applicant shall provide a surety instrument in the amount and form acceptable to the Lyon County Judge Executive upon recommendation of the Planning Commission, sufficient to cover the cost of decommissioning the SES in accordance with the approved plan in the event the applicant defaults in its decommissioning obligations. The surety instrument should be updated and revised in conjunction with a resubmitted decommissioning plan not less than once every 5 years. A surety instrument should be continuously maintained by applicant, their successors in interest, and/or assigns until such time as large-scale SES is decommissioned and all disturbed areas are reclaimed, revegetated, and restored. The form and contents of surety should be in accordance with the requirements of KRS 278-706-2M5 and shall name Lyon County government as secondary beneficiary. F, for projects within SES footprint located within an airport's approach zones or airport imaginary surfaces as defined by the United States Code of Federal Regulations, or within 1,000 feet of an accident potential zone, ABZ1 or ABZ2, the applicant must complete and provide the results of glare analysis through a quantitative analysis of potential impact field test demonstration, or geometric analysis of ocular impact in consultation with the Federal Aviation Administration, Office of Airports, the Kentucky Airport Zoning Commission, and the United States Army for the Campaign Directorate of Public Works. E, decommissioning required. The applicant should begin decommissioning not later than 12 months after large-scale SES has ceased to generate electricity or thermal energy. All structures and facilities associated with an SES shall be removed within 6 months of the beginning of decommissioning. All materials should be recycled or otherwise reused to the extent reasonably practical, and the disturbed area should be reclaimed, revegetated, and restored. 2, order the applicant to decommission a large-scale solar energy system, SES, in accordance with this ordinance and the approved decommissioning plan, shall be grounds for the county to invoke the surety instrument. The county should be entitled to recover from the surety instrument proceeds that are necessary to complete the decommissioning of the facility. Furthermore, should the cost of decommissioning exceed the value of the surety instrument, the county should be entitled to recover the excess amount necessary to complete the decommissioning process. 3, in the event of a failure to perform, default, or failure to extend a surety instrument, the county reserves the right to take all available legal and administrative actions necessary to compel the completion of the decommissioning by the applicant. This includes securing all necessary easements and rights of entry and/or to recoup any public funds expended by the county in the fulfillment of the applicant's obligation. 4, a failure to decommission a large-scale SES facility as required herein is a violation of this ordinance and is subject to the enforcement and penalties as provided herein. F, license or revocation. 1, the Lyon County Judge Executive may revoke a license, subject to a 90-day written notice to the applicant, upon the occurrence of one or more of the following. A, the applicant has 1, provided false or inaccurate information as part of the application for licensure. 2, the false or inaccurate information will result in the siting, construction, or operation of large-scale SES facility in violation of this ordinance. And 3, the applicant has failed to correct the violation through the resubmittal of the approved application and perform any necessary site modifications within the 90-day notification period. B, the applicant has 1, failed to construct or maintain a large-scale SES in accordance with this ordinance and the approved plan, and 2, the applicant has failed to correct the violation within the 90-day notification period. C, the applicant has 1, failed to decommission the large-scale SES facility in accordance with this ordinance, and 2, the applicant has failed to correct the violations within the 90-day notification period. D, the applicant has 1, failed to submit an updated decommissioning plan and accompanying revised surety instrument within 5 years as required by the section 4D, and 2, the applicant has failed to correct the violation within the 90-day notification period, or E, the applicant has failed to transfer the license upon change of responsible entity in accordance with section 7 of this ordinance. 2, any license or revocation issued under this ordinance should be reported to the Lyon County Clerk's Office within 90 days of the reporting of a revocation of the license. The large-scale SES shall cease operation and within 12 months thereafter be decommissioned and in accordance with section 5 of this ordinance. G, license transfer notification required exhibits. 1, change in or transfer of the responsible entity's ownership as contained on a large-scale SES application and a company license shall require the issuance of an amended license which shall be so recorded in the Lyon County Clerk's office. No later than 30 days following the sale or transfer of a large SES facility, the responsible entity that has or is assuming ownership shall provide written notification to Lyon County Judge Executive and shall submit the following information. A, the name and mailing address of the current licensed responsible entity and license number. B, the name and mailing address of the responsible entity assuming ownership with proof of ownership. C, a statement that lease agreements for participating property, if any, are transferable with accompanying documentation. D, a statement of conformance with this ordinance. If SES enlargement or change to the conditions of the original application of an ownership is to occur, a new application as provided in section 3 is required. And E, a revised surety instrument bearing the name of the new responsible entity. 2, within 60 days of the receipt of notification, the Lyon County Judge Executive shall 1, approve the issuance of the amended license, or 2, deny the issuance of the amended license with cause stated. In the review of the license transfer, the Judge Executive may refer the requested transfer to the Planning Commission for recommendation. 3, all other state regulatory laws that are not specifically addressed by this ordinance remain in effect. H, severability. If a provision of this act or its application to any person or circumstance is held invalid, invalidity does not affect other provisions or applications of the act that can be given effect without the invalid provision or application, and to this end, the provisions of this act are severable. I, violation penalty. Any person found to be in violation of this ordinance shall be guilty of a misdemeanor and shall be fined not less than $100 and not more than $5,000. Each day of violation shall constitute a separate offense. J, repeal of ordinance and effective date. Lyon County Ordinance 01/2024 is hereby repealed and replaced as set forth herein. All ordinances or parts of ordinances in conflict with this ordinance are hereby repealed. This ordinance shall be in full effect and force. This ordinance shall be in full force and effect from and after its adoption and approval as provided by law and set forth below. This has been the second and final reading of Lyon County, Kentucky Ordinance Number 04/2024, a solar energy system installation requirements ordinance.
Everybody's still there. All right, any other discussion on the second reading of the solar farm ordinance 04/2024? Myself, yes. Jeff,
Yes.
Bobby,
Yes.
Quinn. Motion passed. You should also have in your packet some information relating to IRBs. Some information was provided to you all in November of 2022, right before the court, no motion was made, at that point. RWE is here, if anybody has any questions related to the IRBs. If you have any.
Judge, if we could, we give a little discussion.
I think everyone knows me here, but Paul Griffin again, representing RWE, the Pleasant Valley Solar Project, and thank you guys for taking time to at least allow us to come talk about IRBs. As you mentioned, it's been brought to the court before, but we wanted to keep the conversation going on that. But again, really appreciate the opportunity to talk about this. We have brought copies to, if anyone in the audience wants to get a copy of what we've presented here today. But yeah, the main topic is obviously what does solar bring to the community and making sure that we drive as much value to the community for the communities that we're operating or would hope to be operating in. And so the main thing that I just wanted to kick it off with is the topic of IRB. You know, it makes sure it's a resolution to make sure that we bring as much value to the community as possible, and that's if we get through the permitting process. So there is obviously still a major permitting hurdle for the project to overcome, but the resolution on an IRB does not approve a solar project. It's only to make sure that if the project does go forward, that we bring as much value back to the local community as possible. And so we have Tim Eichler here today. I think a few of you have met Tim before, but he's a Kentucky tax attorney that definitely knows much more about RODs. And the packet is extensive, but we will keep it short since obviously there's been a lot of discussion on solar already today. So.
Thank you very much. Again, my name is Tim Eifer. I'm a lawyer with Stoll Keenan. And I'm a tax lawyer, but I also do a lot of bond work. And basically, a big part of our practice is economic development incentives. So what we're talking about today would be an economic development incentive. But what's a little bit different about it is we're not asking for local participation. Basically, what we're proposing would be an incentive that would basically save state property taxes, substantial state property taxes, and the company would be able to share that savings with local government. So what we're proposing would be basically a larger revenue stream to local government than it would receive without the bonds. And I want to talk a little bit about how the mechanism works. Solar is a bit unique. We're not talking about a big manufacturing plant. We're not talking about a bunch of new full-time jobs, so it requires kind of an unusual approach to it. But we've actually worked on a number of these. We've had a number of these bond inducement resolutions for solar projects approved. So you should have in front of you a PowerPoint presentation. Also the form of what we call the bond inducement resolution that we're asking you to approve. Should you choose to approve it, it can be read by title. So on the PowerPoint, basically this is an economic development incentive, and while it's styled as a bond, I definitely want to go through a little bit of detail about what that means, because we're not asking the county to borrow money for us. We're not asking you to pledge your credit, your taxing authority. Basically what we're proposing is something that doesn't use up any of your borrowing capacity. It's a revenue bond. So the county acts as a conduit. And at the end of the day here, the company owns these bonds. It owns its own bonds. And you say, why do you do that? Well, that's the only way in Kentucky to get a property tax abatement. The process has been around since about the 1940s. So if you think about a solar project, the bulk of the expenses, the bulk of the capital expenditures deal with the equipment. And under Kentucky law, even if we didn't do a bond issue, any manufacturing equipment, even though it's located in your county, is exempt from local property tax. So the panels, the wires, the inverters, the transformers, all those assets cost a lot of money. But even if we didn't do an IRD, they wouldn't be subject to local property tax. They would be subject to state property tax. So, the primary benefit here is if we do the bonds, and the county controls whether or not this occurs, but if you do the bonds, those assets that are normally subject to state property taxes are abated. So that revenue stream doesn't go to the state, and that savings can be shared with local government. Bottom of page 2, these are not general obligation bonds. So when the county wants to build a new jail, build a new courthouse, and the county issues bonds, those are what we call general obligation bonds. The county's on the hook. If there's a default, the county has to basically levy a tax to repay those, and you pledge your credit. Also, Kentucky law has a limitation on how much you can borrow. Basically, counties can borrow up to 2% of the taxable value of property on tax rolls. Those are general obligation bonds. For revenue bonds, it's different. So revenue bonds are in Chapter 103. The county is not on the hook for those bonds. So the county is not pledging its taxing authority. They don't constitute debt for purposes of those limitations, and they don't impact your borrowing capacity. The sole source of repayment of those bonds is the company. If there was a default, which is not going to happen here because the company owns its own bonds, but if there was a default, the sole remedy would be to appoint a receiver to operate the project, to generate revenues to pay off the bonds. The bondholders can't go against any of the county assets, because the county, again, is not on the hook. The sole source of repayment is the revenue stream. That revenue stream is from the company. Okay. On page 3, actually, I guess the key thing on page 3 is the footnote. you'll see the actual, the bonds, footnote 1 there. Bond statute actually provides that these do not constitute debt for purposes of the Kentucky Constitution. So again, revenue bonds as opposed to general obligation bonds are not debt for purposes of, limitations on the amount you can borrow. They have no impact on the county's ability to borrow funds. They're not a pledge of credit, and they're not a pledge of your taxing power, and the county does not have any risk associated with bonds. The only reason we're doing it is because that's what Kentucky basically says, Kentucky statutes provide. So if you go to the next slide, basically, all of these different solar projects are seeking IRBs, and the question is why? Because the only incentive available to a solar project in Kentucky currently is the IRB. None of the state TEFRA programs apply, KBI doesn't apply, KIA doesn't apply. So, we're not alone. Lots of other projects are probably about the same thing. At the bottom of that page, we've listed a bunch of different projects that have done exactly what we're asking Lyon County to do today, and that is they've adopted a bond inducement resolution, agreeing to issue bonds at the appropriate time to finance the project because there's a pilot arrangement. That pilot arrangement is the company's obligation to make payments to local government during the term of the bonds that not only make local government whole, but make them better off. Oh, you want to talk a little bit about the actual numbers?
Yeah, on page 5, looking at what the numbers sort of look like of what we're proposing, we did put out, what the current property taxes are on the land that we're looking to do the solar project on. And then with doing the IRB, we would then enter into a pilot agreement with the county to create that predictable revenue stream. And so, again, with taxes, there's depreciation and all of that gets calculated into what we would essentially be liable for. With the pilot agreement, there's known revenue at a set rate for the 40-year life of the project. So with this, we're proposing $2,000 per megawatt annually on the 125 megawatt project if built at that capacity. That's why there's an approximate sign there. It's all based on what we would actually install if the project doesn't move forward for the first 20 years and then shifts to $1,000 per megawatt annually for the back 20 years of the project. So looking at that comparative to what the county would receive if there was no IRB in place, it creates an additional $4.8 million directly to the county over the lifetime of the project than what we would have been paying or what the county would receive if there was no IRB. So this translates to about 2.5 times the amount of revenue to the county with the IRB scenario versus a no IRB scenario. And again, this is just a predictable revenue stream that can be used for essential services, schooling, whatever the county deems necessary. So we promised we'd keep it a little short and sweet. The proposal of the next steps, we did put a copy of the draft bond inducement resolution in front of you guys as well. We do have much more detailed explanation in a whole lot of the backup slides of procedurally how it's done, but we didn't want to get too in the weeds with, after going extensively in depth with the ordinance earlier. So we kept it a little high-level summary just to get you guys a little bit of a flavor of what the IRB is and what it is not. And then, we would obviously just ask for, approval on the bond inducement resolution for the solar project, and just open up for discussion there. Again, appreciate you guys giving me the opportunity to at least take a few minutes to talk about solar IRBs.
I don't see any solar IRBs on your list of examples, or all other type of right now.
Skip back page, then have a page number actually, but it's page 4 at the bottom.
It's one of us that does. Okay.
And did you all know too, bill payments, you know, there's what that is for you.
this area. We have 2 in Ballard County. Those both have bond inducement resolutions passed. The one in Metcalfe County, so a number of them kind of in central Kentucky, and eastern Kentucky, but basically they're all, it's the same for all of them. These are simply economic development instead of property tax payment.
Oh, Amanda stepped out, she's our economic development coordinator, if y'all have questions for her. Because we've talked to an attorney as well, it will affect our bond capacity if we were able to do any kind of manufacturing.
If I can speak to that, that's not right.
Yeah.
That is not correct.
Yeah, I think if you all are at all interested in it, we'll just need a little bit more time to talk about it, because Jamie and I have talked to some different attorneys that have spoken about this and like the benefits and costs of doing bonds for solar farms in rural communities, and I think because we've heard different information that you all are presenting, we would just need more time to look at how that actually impacts the county and what the implications are to other, not, maybe not just bonded projects that the county would need to do, but how it would impact other projects at the industrial park if we wanted to do other IRBs.
And we certainly be happy to talk to your council or anyone else you need us to.
Any other discussion? Any kind of motion not to? Anyone? No questions?
You don't have to. If you wanted to, then you can make a motion, if not, you don't have to.
Right now, we have no action taken.
Well, again, thanks for letting us come talk, and yeah, we're happy to provide our resources and make sure that everyone's on the same page and feels comfortable about it, so appreciate the time today.
Thank you.
Thank you.
All right, now we have the second reading of Administrative Code Amendment 05-2024. Motion to accept that ordinance as printed. Motion by Bobby, we have a second. Second by Jeff.
This will be the second and final reading of Lyon County, Kentucky ordinance number 05-2024, an administrative code amendment ordinance. I will be reading this ordinance in the summary. A complete copy of this ordinance is available in the office of the Lyon County Judge Executive during normal business hours. Lyon County, Kentucky ordinance number 05-2024 is an ordinance relating to amending the current Lyon County administrative code to increase the threshold for competitive bidding and repealing and replacing Lyon County ordinance 03-2022. Whereas KRS 424-260 was amended to increase the competitive bidding threshold to $40,000, and whereas the Lyon County Fiscal Court previously adopted Lyon County ordinance 03-2022 to increase the competitive bidding threshold contained in the Lyon County Administrative Code to $30,000. Now therefore, be ordained by the Fiscal Court County of Lyon, Commonwealth of Kentucky as follows. I draw your attention down to section 1 under Administrative Code Amendment. Further, down to Lyon County Admin Code, Chapter 8, Purchases and Contracts 8.2c. You will note the language has been removed from $30,000, which has been struck through, to $40,000. Similarly, under Chapter 8, 8.6, you will note that all expenditures of less than $40,000 rather than $30,000 are still considered small purchases and not subject to competitive bidding. This has been the second and final reading of Lyon County, Kentucky ordinance number 05-2024, an administrative code amendment ordinance.
Any other discussion? Myself, yes. Jeff?
Yes.
Bobby?
Yes.
And Quinn?
Yes.
Motion passes. All right, you should have a copy of our electrical contract budget changes, this is informational purposes, for you all, so at our next meeting in May, on May 23rd, will be the second reading of the budget. However, during the first reading that we read on April the 11th, the court voted for a 2% raise, so the budget will reflect the 2% raise. Postage went up, it will reflect the postage, raise. There will also be confirmation that in the program support for the recycling center, that line item is correct. They would like to purchase 2 Connexon trailers to replace the tire trailers so that people don't have to try to climb those stairs and walk up in them. And the fourth thing is Crittenden County Judge Perry Newcomb has come to me and asked for an increase in the amount that we pay the Crittenden County Animal Shelter. He also asked the same of Livingston County, and Livingston did raise theirs as well. They pay by the month, it's $600 a month, and we pay a flat fee of $4,000. So I'm asking the court for an increase to the Crittenden County Animal Shelter. They had some issues with expanding, they're out of room, they have no more kennels. I don't know if you noticed, they've even talked about changing their, how long they hold animals, 60 days, they've had some there for a year, 2 years, etc. And so I think the least we can do, is double the amount that we pay them from 4 to 8, and I don't think there's an issue with that at all in the budget. But I just need a motion either way. They're gonna, they pay $600 a month, so they'll pay $7,200 a year. And we currently pay $4,000.
I guess my question is, why, how long we been doing this?
We've only paid $4,000, I think, Livingston before they, and we may take more over there than Livingston. I wanna say they doubled theirs. I think they were paying $36. But they did up it to $600 a month to $7,200 for the year. And we've always just paid a flat fee, like July 1, we just go ahead and write the check in that meeting and send it over. You know, right now, there's times when I get texts on a regular basis that they have no room, they will not take any animals that we pick up here. Currently Stan, I think, has one, we're trying to find the owner too, that he'll keep for a couple of days, and his animals before he takes it over, but we can't take it anywhere.
So we're going to write a one-year check, or we're going to do 1 year?
It's totally up to you all, however you all wanna do that. It's just before that, we have the second reading, I'll have to make that change in the budget. The budget has been approved by DLG, but it's not changing any of the, it's just gonna change like the carryover number.
We paid it annually, I'd say we paid it instead of one.
You wanna split it in 2 times a year, or still just make the one payment?
Which one will they vote?
It's not gonna affect our cash flow, is it?
No, sir, it's not.
Whichever's easiest for you and Abby, I'd say just do whatever's easier for you all, that doesn't affect cash flow.
I would do one payment so they can apply. I will also say they're incredibly cooperative with us. You wouldn't believe how many animal seizures we get just from arrest off the interstate, in addition to what we get from the county, and they've been very good to us in the past. I think if you give it to them